Dear viewers, I'm your host Muhammad Asif Jaja and you are watching YouTube channel ETV 786. This channel is for everyone, education for business students and entertainment for general public. Welcome to your own channel. Please watch, like, share and comment the videos and subscribe the channel to view upcoming shows. On this channel, we have completed the basic concepts of accounting. 23 complete lessons may be watched on the channel. Now starting the second study course, Business Law. This is lecture number 4, Introduction to Business Law. The topics will be covered in this session shall be as follows. Number 1, mortgage. Number 2, non-consensual liens. Number 3, bankruptcy. Number 4, personal property and fixtures. Number 5, intellectual property. Number 6, regulations of real estate and environment. Number 7, transfer of real estate by sale. Number 8, landlord and tenant laws. Number 9, estate planning. Number 10, insurance. Number 11, relationship of principal and agent. Number 12, termination of agency. Number 13, hybrid business forms. Number 14, corporation. Number 15, legal aspects of corporate finance. Number 16, corporate power and management. Number 17, securities regulations. Number 18, antitrust laws. Number 19, unfair trade practices. And number 20, international law. Mortgage. A mortgage is a means of securing a debt with real estate. A long time ago, the mortgage was considered an actual transfer of title to become void if the debt was paid off. The modern view, held in most states, is that the mortgage is but a lien, giving the holder, in the event of default, the right to sell the property and repay the debt from the proceeds. The person giving the mortgage is the mortgager or borrower. In the typical home purchase, that's the buyer. The buyer needs to borrow to finance the purchase. In exchange for the money with which to pay the seller, the buyer takes out the mortgage, with say a bank. The lender is the mortgagee. The person or institution holding the mortgage with a right to foreclose on the property if the debt is not timely paid. Like security interest in personal property and suretyship, the mortgage is the common type of consensual security arrangements. Non-consensual liens. A creditor may obtain certain liens without the debtor's consent, which are called non-consensual liens. There are 4 types of non-consensual liens. Number 1, court-decreed liens or attachment liens, which prevent a person from disposing of assets pending a lawsuit, and judgment liens, which allows the prevailing party in a lawsuit to take property belonging to the debtor to satisfy the judgment. Number 2, mechanics liens. Mechanic liens are authorized by statute, giving a person who has provided labor or material to a landowner the right to sell the property to get paid. Number 3, possessory liens. Possessory liens on personal property allows one in possession of goods to keep them to satisfy a claim for work done or storage of them. And number 4, tax liens are enforced by the government to satisfy outstanding tax liabilities and may be assessed against real or personal property. Bankruptcy. Bankruptcy is a legal proceeding involving a person or business that is unable to repay their outstanding debts. The bankruptcy process begins with a petition filed by the debtor, which is most common, or on behalf of a creditor, which is less common. All of the debtor's assets are measured and evaluated, and the assets may be used to repay a portion of the outstanding debt. Upon the successful completion of bankruptcy proceedings, the debtor is relieved of the debt obligations that were incurred prior to filing for bankruptcy. Businesses often file bankruptcy, the goal of which is to recognize, remain in business, and once again become profitable. Filing bankruptcy allows the company to create plans for profitability, cut costs, and find new ways to increase revenues. Their preferred stockholders, if any, may still receive payment, though common stockholders will not. Personal property and fixtures. Personal property is a class of property that can include any asset other than real estate. The distinguishing factor between personal property and real estate or real property is that personal property is movable, that is, it is not fixed permanently to one particular location. It is generally not taxed like fixed property. A fixture as a legal concept means any physical property that is permanently attached to real property, usually land. Property not affixed to real property is considered chattel property. Fixtures are treated as a part of real property, particularly in the case of a security interest. A classic example of a fixture is a building,
which, in the absence of language to the contrary in the contract of sale, is considered part of the land itself and not a separate piece of property. Intellectual property. Intellectual property is a category of property that includes intangible creations of the human intellect. There are many types of intellectual property, and some countries recognize more than others. The most well-known types are copyrights, patents, trademarks, and trade secrets. The main purpose of intellectual property law is to encourage the creation of a wide variety of intellectual goods. To achieve this, the law gives people and business property rights to the information and intellectual goods they create, usually for a limited period of time. This gives economic incentive for their creation because it allows people to benefit from the information and intellectual goods they create and allows them to protect their ideas and prevent copying. Regulation of real estate and the environment. Real property is an important part of corporate as well as individual wealth. As a consequence, the role of the corporate real estate manager has become critically important within the corporation. The real estate manager must be aware not only of the value of the land for purchase and sale, but also of proper lease negotiation, tax policies and assessments, zoning and land development, and environmental laws. In property law, an estate is an interest in real property, ranging from absolute dominion and control to bare possession. A freehold estate is an interest in land that has an uncertain duration. A leasehold estate is one whose termination date is usually known. A one-year lease, for example. The transfer of real estate by sale. Property is sometimes owned by one person or one entity, but more often two or more persons will share in the ownership. Various forms of joint ownership are possible, including joint tenancies, tenancy by the entity, and tenancy in common. Married persons should be aware of whether the state they live in is a community property state. If it is, the spouse will take some interest in any property acquired during the marriage. Beyond traditional land holdings, modern real estate ownership may include interests in condominium, cooperatives, or time shares. The Statute of Frauds requires contracts for the sale of real property to be in writing. Such contracts must include the names of buyers and sellers, a description of the property, the price, and signatures. Most real estate is bought and sold through real estate brokers, who must be licensed by the state. Brokers have different kinds of agreements, including exclusive right to sell, exclusive agency, and open listing. Landlord and tenant law. Landlord-tenant law governs the rental of commercial and residential property. It is composed primarily of state statute and common law. The length of the tenancy is typically classified in one of four categories. Number one, term of year tenancy. The relationship lasts for a fixed period, which is agreed upon in advance by both the landlord and tenant. Number two, periodic tenancy. The relationship is automatically renewed unless the landlord gives advance notice of termination. Number three, tenancy at will. There is no fixed ending period. The relationship continues for as long as the tenant and landlord desire. Number four, tenancy at sufferance. The tenant continues to inhabit the property after the lease expires. Estate planning, wills, estates, and trusts. Wills and trusts are both estate planning tools that can help ensure your assets are protected and bequeathed to your heirs, besides your spouse, which is generally not an issue. Estate and gift tax law allows the passing of wealth to a surviving spouse without incurring gift or estate tax liabilities. However, the transfer process becomes much more involved when wealth is passed to a subsequent generation. It is possible to have both a will and a trust. All wills must go through a legal process called probate, where an authorized court administrator examines them. This process can be lengthy and potentially contentious if family members contest the will. Trusts are not required to go through probate when the grantor dies, and they cannot be contested. Insurance. Insurance is a contract represented by a policy in which an individual or entity receives financial protection or reimbursement against losses from an insurance company. The company pools clients' risks to make payments more affordable for the insured. Insurance policies are used to hedge against the risk of financial losses, both big and small. They may result from damage to the insured or her property, or from liability for damage or injury caused to a third party. There are many types of insurance policies. Life, health, homeowners, and auto are the most common forms of insurance. The core components that make up most insurance policies are the deductible, policy limit, and premium. Relationships between principal and agent. Any person who has the legal capacity, meaning that they are not insane or in certain circumstances a minor, to perform an act may be a principal and empower an agent to carry out that act. Persons, corporations, partnerships, not-for-profit organizations, and government agencies may all be principals and appoint agents. Any individual capable of comprehending the act to be undertaken is qualified to serve as an agent. A contract to be made by an agent on behalf of a principal is considered to be the contract of the principal and not that of the agent. It allows the principal to authorize somebody to carry out her duties either for a specific purpose, such as purchasing a house, or generally, such as to conduct many transactions. The agency relationship is usually entered into by informal agreement, but also can occur by formal agreement. That is, in certain cases, the agency relationship must be specified in writing. The acts must be legal, such as principal cannot hire agent to kill the professor. Termination of agency. Termination of agency takes place in the following circumstances. Number 1, by revocation of authority by the principal. Number 2, by renunciation of his authority by the agent. Number 3, on the performance of the contract of agency. Number 4, on the death of either principal or agent. Number 5, by insanity of either principal or agent. Number 6, with the expiration of time period fixed for the contract of agency. Number 7, by an agreement made between the principal and his agent. Number 8, with the insolvency of principal or agent in few cases. Number 9, when the principal and his agent is an incorporated company by its dissolution. And number 10, with the destruction of the subject matter. Hybrid business forms. This lesson provides a bridge between the partnership and the corporate forms. It explores several types of associations that are hybrid forms, that is, they share some aspects of partnership and some of corporations. Business people always seek to limit their risk and their taxation. A limited partnership is a creature of statute. It requires filing a certificate with the state because it confers on some of its members the marvel of limited liability. It is an investment device composed of one or more general partners and one or more limited partners. The limited liability company has become the entity of choice for many business people. It is created by state authority that, upon application, issues the certificate of organization. It is controlled either by managers or by members. It affords its members limited liability, and it is taxed like partnership. Corporation general characteristics. Corporations have certain characteristics that are unique as follows. Number 1, capital acquisition. Easier for a corporation to acquire debt and equity. Number 2, dividends. A corporation pays its investors by issuing dividend to them. Number 3, double taxation. A corporation pays income tax on its earning. The investors must pay income tax on the dividend received. Lifespan. A corporation can theoretically operate forever, outlasting its owners. Limited liability. Any liabilities incurred by a corporation are not also transferred to its shareholders. Number 6, ownership. Ownership in a corporation is based on the number of shares owned. Number 7, professional management. In many cases, the investors who own a company are not actively engaged in its management. And number 8, separate entity. A corporation is considered to be an entirely separate operating and legal entity. Legal aspects of corporate finance. A corporation requires money for many reasons. There are 4 main sources of corporate finance. The first is plowback or reinvesting profits in the corporations. The second is borrowing, commonly through a bond issue. A corporation sells a bond agreeing to periodic interest payments and repayments of the face value of the bond at maturity. The third source is equity, usually stock, whereby a corporation sells an ownership interest in a corporation. The fourth source is private equity and venture capital. Corporate finance is regulated through a variety of mechanisms through state statutes. A corporation must carefully weigh the pros and cons of each before making a decision to proceed on a particular financing path, as there are some legal aspects and procedures are connected and must be followed. Corporate powers and management. The corporations may exercise all powers expressly given it by statute and by its article of incorporation. A corporation generally has three parties sharing power and control: directors, officers, and shareholders. Directors are the managers of the corporations, and officers control the day-to-day decisions and work more closely with the employees. The shareholders are the owners of the corporation, but they have little decision-making authority. The corporation itself has powers, while a corporation is not the same as a person. For example, a corporation cannot be put in prison. It is allowed to conduct certain activities and has been granted certain rights. A corporation has two types of powers: express powers and implied powers. When a corporation is acting outside its permissible power, it is said to be acting ultra vires. A corporation engages in ultra vires acts whenever it engages in illegal activities, such as criminal acts. Securities Regulations. Many securities regulators around the world have demonstrated increasing interest in the relationship between sustainability issues and their core mandates. While their specific roles, responsibilities, and authorities differ from jurisdiction to jurisdiction, securities regulators are recognized to generally have three overarching and interrelated objectives. Number one, to protect investors. Number two, to ensure that markets are fair, efficient, and transparent. And number three, to reduce systematic risk. This is because sustainability issues can create financially material risks and opportunities for investors and may affect the resilience of the financial system as a whole. Antitrust laws. Antitrust laws are regulations that encourage competition by limiting the market power of any particular firm. This often involves ensuring that mergers and acquisitions don't overly concentrate market power or form monopolies, as well as breaking up firms that have become monopolies. Antitrust laws also prevent multiple firms from clouding or forming a cartel to limited competition through practices such as price fixing. Due to the complexity of deciding what practices will limit competition, antitrust laws has become a distinct legal specialization. Unfair trade practices. Unfair trade practices refer to the use of various deceptive, fraudulent, or unethical methods to obtain business. Unfair business practices include misrepresentation, false advertising, or representation of a good or service, tied selling, false free price or gift offers, deceptive pricing, and non-compliance with manufacturing standards. Such acts are considered unlawful by statute through the consumer protection laws, which open up recourse for consumers by way of compensatory or punitive damages. An unfair trade practice is sometimes referred to as deceptive trade practices or unfair business practices. International law. International law, also known as public international law or law of nations, is the set of rules, norms, and standards generally recognized as binding between nations. It establishes normative guidelines and a common conceptual framework for states across a broad range of domains, including war, diplomacy, trade, and human rights. International law aims to promote the practice of stable, consistent, and organized international relations. The sources of international law include international customs, general state practice accepted as law, treaties, and general principles of law recognized by most national legal systems. International law may also be reflected in international comity, the practices and customs adopted by states to maintain good relations and mutual recognition, such as saluting the flag of a foreign ship or enforcing a foreign legal judgment. International law versus local law. International law differs from state-based legal system in that it is primarily, though not exclusively, applicable to countries rather than to individuals, and operates largely through consent. Since there is no universally accepted authority to enforce it upon sovereign states, consequently, states may choose to not abide by international law and even to break a treaty. However, such violations, particularly of customary and peremptory norms, which are called jus cogens, can be met with coercive action ranging from military interventions to diplomatic and economic pressure. The relationship and interaction between a national legal system, municipal law, and international law is complex and variable. National law may become international law when treaties permit national jurisdiction to supranational tribunals such as the European Court of Human Rights or the International Criminal Court. Sources of international law. Sources of international law have been influenced by a range of political and legal theories. During the 20th century, it was recognized by legal positivists that a sovereign state could limit its authority to act by consenting to an agreement according to the contract principle. This consensual view of international law was reflected in the 1920 Statute of the Permanent Court of International Justice and remains preserved in Article 7 of the International Court of Justice Statute. The sources of international law applied by the community of nations are listed under Article 38 of the International Court of Justice, which is considered authoritative in this regard. Number 1. International treaties and conventions. Number 2. International customs as derived from the general practice of states. Number 3. General legal principles recognized by civilized nations. Additionally, judicial decisions and the teaching of prominent international law scholars may be applied as subsidiary means for the determination of rules of law.
You are watching YouTube channel ETV 786. This channel is for everyone. Respected viewers, you can also watch basic concepts of accounting through above given 3 playlists and homemaking ideas and many more through multiple playlists public magazine, and subscribe the channel for upcoming shows. Bye bye till the next show.